This is passage number 9, duration 6 minutes, speed 100 words per minute. Dictation starts now. The petitioner, a private limited company, has filed this writ petition challenging the possession notice issued by the respondent bank under section 13 of the Securitization and Reconstruction of Financial Assets and Enforcement of Security Interest Act. The petitioner had availed a term loan and a working capital facility from the bank for setting up a textile unit. Due to the sudden slowdown in the market and the non payment of dues by several clients, the petitioner defaulted in the repayment of the monthly installments. Consequently, the respondent bank classified the petitioner's account as a non performing asset and initiated recovery proceedings by issuing a statutory demand notice. Para. The learned counsel for the petitioner argued that the bank has failed to follow the mandatory provisions of the Act before taking symbolic possession of the secured assets. It is submitted that the petitioner had submitted a detailed representation seeking restructuring of the loan, but the bank rejected the same without providing any valid reasons. The council further contended that the valuation of the property done by the bank's approved valuer is much below the actual market rate. He urged that this court to grant some breathing time to the petitioner to bring a prospective buyer and settle the entire outstanding amount through a one-time settlement scheme. Para. On the other hand, the learned counsel appearing for the respondent bank raised a preliminary objection regarding the maintainability of this petition. He argued that the petitioner has an alternative and efficacious remedy available under section 17 of the Act by filing an appeal before the Debt Recovery Tribunal. It is well settled that the High Court should not entertain writ petition in commercial matters where a specialized forum has been created by the legislature. The bank maintains that the petitioner is a habitual defaulter and the current outstanding dues have crossed 50 crore rupees. Therefore, the bank is entitled to take physical possession and conduct a public auction to recover the public money. Para. We have perused the documents and considered the legal possession. The SurFaci Act was enacted to provide a speedy mechanism for banks to recover their dues without the intervention of the courts. The powers granted to the banks are indeed very wide and therefore they must be exercised with great caution and strict adherence to the rules. However, we agree with the respondent's contention that the petitioner ought to have approached the tribunal first. The tribunal has the power to examine the factual aspects, including the correctness of the account statements and the valuation reports, which cannot be done in a writ jurisdiction. Para. Furthermore, it is observed that the petitioner has not deposited any substantial amount to show its bona fides. Mere statements of intent to pay in the future cannot stay the recovery proceedings initiated by a financial institution. In several judgments, the Honorable Supreme Court has cautioned the High Court against granting stay orders in banking matters as it hampers the overall economy. Unless there is a patent illegality or a jurisdictional error, the court should allow the bank to proceed as per the law. The petitioner's request for Structuring is a matter of commercial wisdom of the bank and cannot be detected by the court. Para. In view of the above, we are not inclined to interfere with the impugn notice at this stage. However, to meet the ends of justice, we grant liberty to the petitioner to approach the debt recovery tribunal within a period of 2 weeks. If the petitioner deposits 20% of the demanded amount with the bank, the physical possession shall not be taken for a period of 1 month. This order is passed without prejudice to the rights and contentions of both parties. The petition is disposed of accordingly. No order as to costs. All pending applications filed in this matter stand closed forthwith as per judicial protocol. Over. Stop.